Good evening. It's 7 o'clock. Would like to welcome you and call the meeting of the Board of Adjustment of the Town of Mills River to order. First, are there any adjustments or additions to the agenda? Nope. Then I'd like to entertain a motion to approve the agenda. All in favor?
Aye.
Agenda approved. We have minutes of our last October 10th meeting last year. Like to entertain a motion to approve the minutes.
Motion to approve the minutes?
All in favor say aye.
Aye.
Minutes approved. Next is public comment. Do we have anybody signed up for public comment? No?
I think everyone here is public
Evidence here. Okay, thank you. Then we go on to new business. Election of chair and vice chair of the board. Any discussion?
I'll just introduce it. Every year, the first year the the first meeting of the year the Board of Adjustment has, we elect a chair and vice chair and adopt the annual meeting schedule. So those are the two items on your agenda. So again, it's at the board's pleasure to make nominations and appointments for that. This just happens to be our first meeting for the year so far.
Anybody willing and brave enough to make a motion? I guess I gotta say, all in favor, say aye.
Aye.
Thank you very much. Then I nominate my famous cohort here as vice chair.
Second.
All in favor?
Aye.
Aye. Thank you very much. Next, I'd like to entertain a motion to adopt the 2024 Town of Mills River meeting schedule.
Second.
All in favor?
Aye.
Adopted. And then next, we go into evidentiary hearing VAR 2401. Let's see. I am supposed to read. Well, I guess we first got to decide to go into the hearing, like entertain motion.
Motion to start the.
All in favor, say aye.
Aye.
All right. Then I do my reading. This is a quasi-judicial evidentiary hearing. This means it's like a court hearing. North Carolina state law sets specific procedures and rules concerning how this board must make its decisions. These rules are different from other types of land use decisions like rezoning cases. The board's discretion is limited. The board must base its decision only upon competent, material, relevant, and substantial evidence in the record. A quasi-judicial decision is not a popularity contest where opinions are considered. This is a decision constrained by the standards in the Mills River Code of Ordinances and based on the facts presented. If you will be speaking, please focus on the facts and ordinance standards, not personal preference or opinion. Participation in this hearing is limited. This meeting is open to the public. Everyone is welcome to watch. Parties with standing have rights to fully participate in the hearing. Parties may present evidence, call witnesses, and make legal arguments. Parties are limited to the applicant, the Town of Mills River, and individuals who can prove they will suffer special damages as a result of this decision. Other individuals may serve as witnesses when called on by the board. Witness testimony should be limited to the facts, not opinions. General public comment is not permitted during the hearing. All witnesses must swear or affirm their testimony. In one moment, the clerk will administer oaths for all individuals who intend to act as a witness or provide testimony. Will the clerk take that action?
You skipped step number 4.
Oh. Excuse me. Uh-oh. I'm missing the steps. Did I have it? I'm sure they're here. Too many papers. Okay. Yeah, thank you. Do any of the board members have any personal knowledge upon which they may rely that is not in the record? Oh, no. Then we would like to recognize any person wishing to petition the board to act as a party with standing. And there's two options there. Standing gives the person special rights in the hearing, cross-examination of witnesses, making motions or objections, challenge the impartiality of a board member, appeal the decision, etc. To be a party with standing, the person must prove legal interest in the subject property, that they will suffer special damages, or that they are a homeowner association or neighborhood community association not formed in response to the case at hand. Then next, we would like to swear in, or the clerk would swear in those to present evidence.
So I believe we have the applicant, Mr. Miller, here tonight, and the property owner, and then obviously I'll testify on behalf of the town. There's no one else, no other special parties petitioning for standing. So if you do plan to speak as part of this hearing tonight, we ask that you swear an oath with the clerk now.
Can I get your name also?
Mitch Miller, I'm the applicant. Michael, do I need to speak or just?
I would stand up and swear in just in case they ask you a question.
Okay.
Y'all will raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Thank you. Then next, we would recognize our planning, zoning director, staff to present the case and enter preliminary materials into the record.
Great, thank you, everyone. So again, just reiterating what the chair said, we're here tonight to hear a request of Mitch Miller of Double K LLC, who's acting as an agent for the current owner of the property, Ruth McEntee. And the request is for a 25-foot variance from the front yard setback in the neighborhood commercial zoning district and a 15-foot setback from the 30-foot side yard setback for the neighborhood commercial district. So if granted, the front yard setback variance would change the new front yard setback to 35 feet versus 60, and the 15-foot side yard setback variance would change the new side yard setback to 15 feet, not 30 feet. So we got the complete paid variance application on March 6th with supporting materials. The applicant, I'm just going to summarize what was on the application. The applicant claims unnecessary hardship due to the small 0.43 acre size of the existing lot, which was platted in 1982, well before the town of Mills Rivers Incorporation and minimum lot size standards were established. Due to the small size of the lot, with a width of 125 feet and depth of 180 feet, the property will not accommodate a house and septic with the existing setback requirements. Again, current setback requirements are 60 feet for front and 30 for side and rear. The applicant also claims the requested setback variance will allow a home on this lot to blend with the existing neighborhood. Neighborhood restrictive covenants require homes be placed according to a 35-foot front yard setback and 15-foot side yard setback, which is what the applicant's requesting. The hardship, the applicant claims the hardship's not of their own actions, and the variance is within the spirit, purpose, and intent of the ordinance, since he's trying to build a home in harmony with the neighborhood. The evidentiary hearing was properly noticed. We sent public notice letters out to adjacent owners on March 19th and ran advertisements in the Hendersonville Lightning on March 27th and April 3rd. And then the materials I'm submitting into the record are the variance application, which is attachment A. We have the appointment of agent form as attachment B, an excerpt of the neighborhood commercial zoning ordinance with the highlighted sections the variance is being requested from as attachment C, Staff did include just an aerial view of the subject property for reference as attachment D, and the remaining exhibits were provided by the applicant. The Windover Woods subdivision plat from 1982, which consists of all the homes on Blackberry Lane, is attachment E. The Windover Woods restrictive covenants is included as attachment F. And then the applicant put together a setback exhibit demonstrating approximate measurements for the front yard setback for the existing homes on Blackberry Lane. That's attachment G. And then we have our certificate of mailing of public notice letters as attachment H. And that's all I have to offer into the record at this point.
All right. Then next we would like to recognize the applicant to agree or object to any of the exhibits that were just brought to our attention or anything.
I did discover, Michael said 180 feet, it's actually 150 feet, so through trying to get the house sited and meet with the county septic inspector, it's even a little tighter than flat red, but that's the only new information I have.
Okay. Thank you. Next, any questions by the board members to our planning and zoning staff?
I'll just add my usual one. I'm assuming no one responded, even though this is clear positively to the mail.
That's correct. We sent, I forgot to mention, the public notice sign was up as well in the front yard. We got maybe 3 calls with inquiries about what the request was. That was it.
Thank you.
Any other? Then next, recognition of the applicant to present evidence or testimony.
I'm happy to speak if anyone has
If
questions.
you want to come up to the,
I don't have nothing else to say, I guess, other than the evidence, but I'm happy to answer questions.
okay,
I'll come up here in case
Yeah.
someone has questions.
that'd be good. Any questions to the applicant at this time by any of the board members? None? We don't have to recognize anybody else because there is nobody else. So that's simple. We don't, that's the next one. Thank you very much.
Yes, sir.
Preliminary discussion. Board by the board, we can ask for input from any party or witness, obviously the applicant and the staff, if there are any other questions.
Can you just show me on one of these maps which property it is? I was getting,
It's lot number 4.
thank you.
That helps you.
Yeah.
This is where we are. Okay, I found lot 4.
Any other questions in our preliminary discussion?
Blackberry Lane, is that a statement in another? Right away, lot, or road like this. Right of way usually reserved. A lot of right of way in case it ever has to be widened. That's a lot of right of way.
Okay. Any other input in the preliminary discussion before we vote to close the evidence portion of the hearing? If none, I'd like to entertain a motion to close the evidence portion of this hearing.
I'll make a motion.
Second.
All in favor say aye.
Aye.
That closed our evidence portion. Then next is deliberation of the board, considering all the factors set out in the ordinance. Well, it's sort of split up here for maybe complicated cases. So we first have the deliberation of the board, considering all the factors, and then we have continued deliberation after review of the proposed findings of facts. So maybe we should start with proposed findings of facts.
And just as a reminder, just to help staff in drafting the decision document, when you do propose to make a finding, if you could just point to a piece of evidence or something in the documents provided supporting that.
Mr. Chair, if I can be recognized.
Yes, sir.
For the first element, the unnecessary hardship, I feel that unnecessary hardship would result in the strict application of the ordinance due to the fact it would make the property unable to accommodate a house and a septic tank.
Do you want to put that in the form of a motion?
If it's the appropriate time, I will.
I would.
I'll make a motion that an unnecessary hardship would result from the strict application of the regulation and the fact that the strict application would not allow the property to accommodate a house and a septic.
Second.
All in favor?
Aye.
Aye. That motion was approved.
I'll make another motion.
Go ahead.
The hardship results from conditions that are peculiar to the property, as the other houses in the area were plotted under the old ordinance. And this one, the house would be required to meet the new ordinances. The fact that it has to meet the new ordinances makes this particular to that specific property, and a hardship would result from that.
That's a motion.
That is a motion.
A second.
All in favor say aye.
Aye.
Aye. That one passed.
I'll make a third motion.
Thank you.
The hardship did not result from any actions taken by the applicant or the property owner as the property was platted in 1982.
I second that.
All in favor say aye.
Aye.
That motion was approved.
I'll make a fourth motion, unless somebody else
That's
wants to
it.
jump in there.
You're
The
on a
requested
roll.
variance is consistent with the spirit, purpose, and intent of the regulation as,
Ordinance.
of the ordinance, as it will help the home blend in with the other homes in the area, and that it achieves justice and fairness by accommodating a property that was established under old ordinances and not forcing it to meet new requirements that it cannot meet.
I second.
All in favor say aye.
Aye.
That motion was approved. So now I would like to entertain a motion on the variance with or without conditions, as we approved all 4 individual motions according to standard.
I make a motion that we adopt, the variance requested under VAR -24-01, in as much as all of the 4 requirements have been met and were agreed to by the board.
I'll second.
All in favor say aye.
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 Then we can say that this variance has been approved with a unanimous vote of the Board of Adjustment. Like to entertain a motion to close and adjourn our evidentiary hearing.
Motion. Motion to close our evidentiary hearing.
Second.
Second.
All in favor?
Aye.
Thank you. Next announcement, our next regularly scheduled meeting is June 11th. And next, I would like a motion to adjourn.
Motion to adjourn.
All in favor?